Welcome all. This is our lecture 17 of the subject Law for Engineers, and the today's topic is arbitration. In the previous videos, we have learned what is ADR, means what is alternative dispute resolutions. These provide some ways that without going to court, how can we settle, how can we resolve any dispute. So in ADR process, there are many processes which we are follow to settle any dispute. The most important one and the very high accuracy process is arbitration. So by today onwards, we will discuss about these processes. In today's lecture, we will discuss about arbitration. In the upcoming videos, we will learn about the other processes. So let's start with the topic arbitration. As it's a process of ADR, so it has some rules that without going to court, we can settle our dispute. Arbitration. A neutral person called arbitrator hears arguments and evidence from each side and then decides the outcome. It means in arbitration process, we have an external party that's called third party that can be, and the both the disputes parties should agree on that particular. The court can also appoint some attorneys or some representatives to settle any dispute. Arbitration is less formal than a trial, and the rules of evidence are often relaxed. In binding arbitration, we have two types of arbitration. That is, one is binding, and second one is non-binding. What is this binding and non-binding? We will discuss about it in the upcoming slide. In binding arbitration, parties agree to accept the arbitrator's decision as final, and there is generally no right to appeal. And in non-binding arbitration, the parties may request a trial if they do not accept the arbitrator's decision. Okay, and in the case conferencing, a judge or the judge's representative meets with the parties and their attorneys to try to settle some or all of the issues in dispute before going to court. As I told you that court can also appoint any third party to settle any dispute. This is our binding and non-binding process. A binding decision is a ruling that the parties must abide, be whether or not they agree with it. It means parties must have to accept that decision. Okay, they are agree with that or they are not agree with that, that's their problem. Okay, the decision should be final. But in the non-binding decision, a ruling that the parties may choose to ignore. It means any of the party can ignore the decision or go for any court trial or for any other process. These are some general principles of arbitration. The object of arbitration is to obtain a fair resolution of disputes by an impartial third party without unnecessary expense or delay. This is the necessary condition that the third party must be impartial. If that have some close relation with any of the party, then the decision should vary or the decisions should not be in the proper form. So the third party should be impartial, or we can say that should be neutral, or should be the equal to the all the parties. The parties, second one is the parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. and the court should not interfere. It means in the decisions, in the proceedings, in the evaluation, the court should not interfere. Okay. These are some principles of arbitration. The arbitrators or tribunal members are commonly appointed one of the three means. We have three means. Then how can we choose or how can we appoint a arbitrator? First one is directly by the disputing parties, as the parties in a dispute by mutual agreement can appoint any third party as an arbitrator. Second one is by existing tribunal member. It means there is an defined members in the tribunals, they can select from that. Okay, any particular person or the tribunal can final as per the dispute, or the subject matter expert can appointed by the tribunal. Third one is by an external party. For example, the court or an individual or an institutional nominated by the parties. As I told you, the court can also appoint an arbitrator or an individual, because to settle any dispute or settle any matter, the arbitrator should be an expert of that particular dispute. So he or she can provide some better decisions. Now we will learn about some advantages of arbitration. It have some, as we all know, the arbitration or the ADR have some advantages over the court trials. So the most commons are choice of decision maker. It means the parties can choose a technical person as arbiter, as if the dispute is on a technical part. Can you understand? That is technical part. It means a technical person must be involved to settle that particular dispute. And in the court, if the two parties going to court, then court will also appoint an technical person, because the court personnel, it's not necessary that court personnel should have knowledge about that particular issue. Okay. Efficiency, it's more important that arbitration can usually be heard sooner than it takes for court proceedings to be heard, as the court has some limitations and the court have some procedure which should be followed by both the parties. It's not happen that you can go to court and hear my dispute or hear and final it. It has some procedures you must have to follow, as you have all heard that date on dates, that's tariq per tariq, that's concept will be followed. Privacy, this is the most important advantage of arbitration or the ADR process, that the privacy should be maintained, because the subject matter which will be discussed will be within the parties and the arbitrator as well, and all the evidences and the matters will be confidential. Okay. And in the court, you all know, in the court you can sit, or there should be any lawyers, there should be any police persons, there will be any news anchors also, so they can disclose the private information. So this will provide the parties privacy. Next one is convenience, as if you go to court, the court will work according to court time. Okay, but In the arbitration process, this will take place according to your convenience. Okay, you can schedule the hearing in the morning, in the evening, in the night, as per your convenience. Okay, or as per the convenience of witnesses as well. Flexibility, you can change the schedule, you can change the venue, etc. as well. It will provide with the flexibility. The finality, it means the decision should be made within some sort of times. Okay, this will depend on the parties and on the process which are followed, that is binding or non-binding. So this is all for this lecture. Prepare your good quality notes and study.